Appeals Division 1 is now in session.
Good morning. Be seated. Now is the time set for oral argument in cause number 1 CACV 150566, Gillespie v. Wallace. For your information, for everybody's information, for the entire crowd's information, these proceedings are being both audio and video recorded, so barring any unforeseen problems, those recordings should be available on YouTube in a couple of weeks. And that is our obligatory comment in that regard. Counsel, each side will be entitled to the usual 20 minutes, and we, of course, would ask that you respect that time period. The timer located on the podium will let you know how much time you have left, and Mr. Abney, if you wish to save some time, you're going to need to let us know what it is so that we don't eat up all of yours. Or try not to. How's that? We've reviewed the briefs. We've conferenced the case this morning, so we are aware of the facts and the issues. Let that be somewhat of a direction for you in regard to how you use your time that you do have. Counsel, as always, when you come to the podium, we ask that you state your name and who you represent. And with that, Mr. Abney, it's yours.
Thank you, Your Honor. May it please the Court, my name is David Abney. I represent the plaintiff appellant. The main point that I would hope to make today would be that the claim here, the primary claim, does not arise out of a contract express or implied.
Wait. At this juncture in the proceedings, Mr. Abney, is your client's position that there is a contract or that there's not a contract?
There's clearly a contract. It's an implied contract.
Okay, so in the opening brief at page 23 where it says there is no contract, we just assume that that's no longer in play?
That's an excess of zeal, I think. There is a contract. If you hire onto a law firm, there's an implied contract. In this case, there wasn't an express one, was not an express one. But there's clearly an implied contract when you hire onto a law firm or go to work for a government agency that you're going to do your best efforts as a lawyer and you're going to get paid for it. There's a whole lot of other conditions that can be added to that sort of arrangement. There's many times, for instance, where you could have a lawyer who is doing outside work, an off-counsel attorney, for instance, or even in a traditional law firm, you could have a lawyer who's handling some cases, winding down cases, or even have a few cases on the side that may be of a different nature from what the law firm usually does. Pro bono cases, for instance, all kinds of things that you do that can be on the side. But there's clearly an implied contract. It's one of those implied in law contracts that you're going to do work, you're going to get paid for it, et cetera. But separate and apart from that, when you hire on as a lawyer in any place, whether it's government, private, there is a fiduciary duty of loyalty that you owe to your employer. There's many aspects of that. Certainly a duty not to compete, and I don't think there's any real disagreement about that kind of basic idea that there's a duty of loyalty and duty not to compete. Where you get into trouble in this case is exactly what does that mean for this particular lawyer under these particular circumstances.
Aren't those issues jury issues, though?
Whether there's a contract and a breach of contract?
Let's assume that we agree with everything you say.
I hope so.
Well, okay. But let's assume that. And then we get to the issue of the breach of fiduciary duty.
Right.
Whether there was a breach of fiduciary duty or a violation of the duty of loyalty. The jury rendered a defense verdict on that claim, and I would have thought they would need to sort out, well, was the Burke case included or excluded from the consent or from the willingness to allow Ms. Wallace to continue working on it? What were the parameters? And they obviously rendered a defense verdict, so that would suggest that they found that the Burke case, she didn't violate any fiduciary duty or duty of loyalty by working on that case.
Sure looks that way to me, Your Honor. I mean, there were a whole bunch of theories alleged. When
right.
Push came to shove, I think what was really the breach of fiduciary duty claim, and then there was the contract claim. Those were the stars of the show. The case started out with 13 causes of action, including faithless servant, which I'd never seen before and had to look up, and I still don't know how exactly it fits. But yes, I think the jury did decide straight down the line that there was nothing. What puzzled me when I went through the transcripts, and I came into this case very late, so I've been reading until my eyes were bleary. But when I went through the transcripts again, even more scientifically, because I could do a search, the word fiduciary doesn't even appear into the case as far as the jury's concerned. They don't even hear the word fiduciary until the very last day. And the first time they hear it is a jury instruction. And then you get some argument from Mr. Durant about fiduciary duty. I don't think that Attorney Wallace's lawyer even breathed the word fiduciary duty in his closing argument. I don't think he even mentioned it. But then again, at that point, I believe they thought they had pretty much had the case in the bag and didn't need to mention it.
Why are you here today?
Because there's this huge award of attorney's fees.
$50,000.
Bigger than that. As far as I could, unless I misread the, if I may.
Forgive me, I may be getting confused, but it's significant. Yeah, it's significant.
So it's $280,000 or something bizarre.
Right, yeah.
The tail wagging the dog, and here we are here about the tail, not the dog, really.
Wasn't that in large part of your client's own making?
Well, anytime you start litigation, there's going to be some unfortunate circumstances if you don't win, and they didn't win. Whether it's own making or not, I don't know. But the issue is really, does this arise out of a contract, or is it arising out of something fundamentally different? What's the essence of the case?
We have lots of cases in this state that if a party sues for breach of contract, and your client did sue for breach of contract along with other theories, and the defendant shows there was no contract at all, our case law recognizes that is still nevertheless an action arising out of contract for purposes of 12-34101.
Yes, but you have to. Well, your book, you have to.
I know, it's my book. Yes,
you have to dig down to what the essence of the case is really about.
Well, and here the jury was instructed on breach of contract
and on breach of fiduciary duty.
And breach of fiduciary duty.
Correct.
So what was the scope of the fiduciary duty depends in large part on what the parties agreed to as part of their contractual arrangement. But even if, let's say for the moment, we find them completely separate theories, absolutely separate, the two do not meet. Under the entwined doctrine, or the entwined doctrine, where a lot of the same evidence, a lot of the same work would go to dealing with prosecuting and defending on both theories, we have case law that would recognize that, yes, you can get a fee award when these claims are so entwined with each other, even though one by itself would not trigger a fee award under the statute.
Yes, but the essence of this particular case is a fiduciary duty, and that exists whether there was any sort of contract or not. Certainly there's no express contract. But as far as the implied contract, it really made no sense to have it in the case. Of course, the implied contract, it basically is sort of part of the relationship between the parties. You're hired on, there's an implied contract. But there's also this separate fiduciary duty that is owed by the lawyer to the law firm.
But counsel, you say that the essence of the case is this fiduciary issue.
Yes, Your Honor.
And then you tell us that the word fiduciary doesn't even show up until the last day of a 4-day trial.
I cannot account for that other than, go ahead, Your Honor.
And then when you flip that around, there is a separate section within the opening brief that lets us know that there is no contract in this case. So fiduciary doesn't come up until the end of the trial, and contract is tossed out in the opening brief. It seems to me like this is kind of a theory, an embryonic theory of a case that I'm not sure what it is when it matures. Does that make sense to you?
It does, and in part, I think it starts with the complaint itself. I mean, it reads like an exercise for or a law. What do they call those? Yeah, bar exam question. That's what it reads like, where you're supposed to identify every single issue you possibly can, say a little bit about it, and then go on to the next question. And so they threw in 13 causes of action. But the thrust of this case, the crux of this case, is the breach of fiduciary duty.
So if they had exercised a little discretion and narrowed the focus in their complaint and in their presentation to the jury, perhaps their fee award wouldn't have been the $280,000.
It would have been helpful. It would have been better lawyering all the way around to get to the heart of the case and stick to the heart of the case. That's the hardest thing for lawyers to do, though. You don't want to set aside something that might come along later just in case somebody accepts that kind of theory. Absolutely, it should have been narrowed down. Contract, oddly enough, and I checked this too for trial days 1, 2, and 3. There's some tangential mentions of contract, but that's not really the focus of what's going on at the trial either. I don't know. I think what happened here is that the lawyers were worried, for the plaintiff, were worried that fiduciary was too hard an idea for the jury to deal with, so they wanted to save it to the end and try to explain it, which Mr. Durant tried to do.
Isn't this problem... what we have is a case that was tried on a variety of theories, including breach of contract. It went to the jury, and the jury rendered a complete defense verdict. And now you're here to say, well, really, the essence of this case was the fiduciary duty. But that's not how this case was handled and tried and presented. It was World War III scorched earth in large part. And we can't ignore the reality of what happened in the trial court to somehow eliminate, reduce the attorney's fees. Because that's just not, they were awarded based on the reality that existed when this case was filed, prosecuted, and tried.
But they are awarded based upon a statute which requires that that the claim arise out of a contract, express or implied, and it didn't.
Yeah, you're making an earnest argument, and I hear you. But I've mentioned the cases involving when you show there's no contract. I've mentioned the cases involving when you have a supposedly freestanding tort claim or a claim that does not trigger the statute, intertwined with claims that do trigger the statute. And this court, I believe, last year issued 2 cases, modular mining, I think, is one of them, plus another one, that deals directly with intertwined claims. And we have recognized in those 2 cases and in a whole bunch of cases before then that when that happens, you can get fees even for for work on a tort claim if in fact it was necessary that same work was needed to deal with the contract claim.
I recognize that, but I do not think these claims are intertwined. There is an implied contract, certainly, no question about that. But what are the terms of the implied contract? Nobody ever established what those terms were.
Well, let's talk about that for a minute. Do you agree that in this implied contract there was a specific provision? I know that sounds contrary, but there was an agreement that Ms. Wallace was going to be able to wrap up California cases.
There was some sort of agreement to the fact that she was going to be winding down the California cases.
And her testimony was that was discussed at the interviews that she participated in, and there was an agreement reached with the firm when they extended the offer that she was going to take care of these cases. And the Burke case was one of those cases.
Yeah. However, what you're talking about there is some sort of an express agreement, which,
well, in her mind, at least in her mind, the Burke case was one of those cases.
That was her position.
The counsel, whose responsibility is it to ferret that out, to flush out exactly what cases are you bringing into our office that you're going to be working on while you're with us? Whose duty is that? I don't mean to make it in terms of a duty. Whose responsibility is to make that part of the agreement, implicit or otherwise?
Well, it would seem to me if you are really on top of your game as an office manager, you probably want to have some sort of a written contract that deals with all these sorts of things. I've hired on to several law firms in my career, and I don't think I ever had a contract.
Well, certainly someone had the forethought to run a conflict check, and you would give a list of your clients to make sure the firm is not going to have either be conflicted off at pre-existing clients that the firm has, or that firm will cause you problems with your clients. I'm just stunned that apparently
Counsel.
this wasn't done in this case.
Counsel, I'm shocked that an E&O insurer would have said, yeah, just bring her in, and whatever she's working on, we'll just cover any claims that are made against you as a result of her working on it while she's in your office, and nobody bothered to say, what is it that she's working on while she's with our office that is not something that we should be responsible for?
I don't think this isn't the greatest office management system I've ever heard of, put it mildly. But we have a bit wandered from the point of the case.
Yeah, I'd like to come back to that,
Yeah, sorry.
if I may. And that is, given the verdict in this case, and the fact that we're going to review this case in light of that verdict, the jurors believe the Burke case was one of those cases.
Probably yes. Then again, they could have reached their decision simply because they thought the case was really about breach of fiduciary duty. They didn't find it, and they decided to throw it out. I mean, there's no way to psychoanalyze a jury now.
But doesn't that problem fall on your client's shoulders? Your client could have submitted or requested the court to give special interrogatories, or could have refined this case more.
That would be helpful for understanding what the jury was thinking. But what matters here today, what was the trial court thinking? Did the trial court correctly interpret and apply the statute? And I send it to you, they didn't, because the essence of the case really was breach of fiduciary duty. And I know that this was like some sort of big chocolate cake you cover with ice cream and icing and everything so much you can't identify what it was to start with. But the point here was it's the judge's job, and of course now it's your job to decide what the essence of this whole thing was. Early on, the judge was thinking this is a contract sort of thing. I think that was the thrust of what the judge was thinking. But what the Gillespie firm wanted was, what touched this off was the money, a huge amount of money for them had come into the law firm. They figured out where it came from, and they said, this is wrong. This is a breach of your fiduciary duty to us. The money really belongs to us. That's an equitable fiduciary duty kind of claim. All the stuff that got added onto that didn't need to be there. This is not a claim that arises out of a contract. If you get rid of the contract entirely, implied, expressed, the whole thing, the case is still the same as it really was at the beginning. It's a fiduciary duty problem. You breached your duty to us, and therefore you have to disgorge everything that you got in breach of that duty. That's really the essence of the whole case. You don't need the contract at all. And if you don't need the contract at all, then 12341.01 doesn't apply. You know, this intertwining thing is more as a result of really strange sort of pleading and strange sort of argumentation that missed the essence of what happened. No wonder the trial judge was scratching his head, and no wonder the trial judge, I submit to you, reached the wrong decision. You can, as the Dooley case deals with defending against a breach of fiduciary claim, you can't recover attorney's fees for that. That's the Dooley case.
Counsel, that's in a purely fiduciary case, right?
No, there were mixed, I believe, and I'll check when I sit down, but I believe there were mixed claims in that case.
We have case law that says that even if the jury decides on an issue that has no bearing on the contract, completely separate and aside from a contract, if the contract is alleged to have existed or if it is based in a contract, something completely outside the contract that they decide on can still lead to attorney's fees. So,
yes.
So I'm a little lost on your notion that there was no entitlement.
Yes, but I submit to the court that the true issue, the real problem here is that if you get rid of the contract entirely, you're still here. You have the same sort of claim. The contract, and the implied contract, which is really what we're dealing with, what are the implied conditions of the implied contract? You never got there. There was some talk about express agreement, this, that, and the other, but you never got to the big issue. Well, an implied condition of your contract is that all work you're doing while we are paying you is going to be work for us, and everything you bring in is going to be ours. That's not it. There's never any proof that was any sort of condition of the implied contract. Nobody ever proved that, and that's the essence of the implied contract claim.
We have a general verdict, a general defense verdict, which is a problem here, I think, for the arguments you're raising. But it strikes me that this is the central issue in the case, in my view, was what did the parties agree was going to be, that Ms. Wallace would be allowed to do. And if, under her view of the facts, which the jury, given the general verdict, may well have accepted, was that the Burke case was okay, then there's no breach of fiduciary duty here. She didn't do anything that was disloyal or in violation of her fiduciary duties that she owed her new employer. So you still go back to what was the party's contractual agreement. We can't strip that out.
Well, it really wasn't a claim that should have been there to begin with.
But it was there. But it really was there. It went to the jury. There were motions for summary judgment. I've looked at this record. It's enormous. And we can't ignore the reality of how this case was tried.
But you have to, in a sense, you have to ignore the reality of how it was tried, because the issue is the dust is settled, the case is over, the judge now has a request for attorney's fees based on the statute. Then you have to decide what was the essence of the case.
I will tell you, I believe your client would have been in a stronger position in making this argument if it had argued in its response to the fee application that there needed to be allocation or apportionment between the fiduciary duty work and the other work. They didn't argue that. They didn't raise those points.
You mean between the claims?
Yes.
Yeah.
They didn't say, hey, judge, no matter what, they're not entitled to 80% of the fees because they related to fiduciary duty work. They didn't make any effort to do that, and they made no argument on that, as I recall.
Well, this is, pardon the analogy, but this is sort of like an opinion that the court issues. You can always write it better. If you just have a little more time, you probably look at an opinion you wrote 3 years ago and say, "Oh my gosh."
Usually, I have that feeling too. Yeah.
Yes, but you know, we can't, in hindsight is a wonderful thing, but we can't go back and start to retry the case. What we can do is say, "Okay, trial judge, here you are. The case is over. What is the essence of this contract?" And the essence is breach of fiduciary duty, and Dooley had several claims: fiduciary duty, misappropriation of corporate opportunity, fraudulent conveyance, and several claims for accounting. So it was a multiple kind of claim case. I would reserve time, but it's all gone.
Thank you, Mr. Abney.
Thank you.
Morning, may it please the court. I'm John Condry. I actually tried this case on behalf of Ms. Wallace. So the history of this case is known to me. And one thing that looking through the record of this case would make clear is that it was not tried on a breach of fiduciary duty theory.
Counsel, were you a part of this case from the get-go, to use the vernacular? When did you come in just before trial, or did you go through the pleading stages preparing for trial?
I did not go through the pleading stages from the very beginning. However, I did not parachute in just for the purposes of trial. I came in, I would say, approximately a year before, and I would say that even that 1 year was a torturous process.
Were the efforts pre-trial directed at a fiduciary claim?
No.
There were 13, Mr. Abney's been very direct with us on this, that there were 13 causes of action alleged in the complaint. Were the 13 causes of action all, if you will, being prepared for trial?
The only causes of action that were tried to the court were breach of contract, breach of the duty of good faith and fair dealing, and breach of fiduciary duty.
But my question, and I'm sorry, my question, what I'm trying to get to is this. If the objection is that this vast amount of attorney's fees was incurred on a case that was only really limited to one issue, which was fiduciary, my question was how much time was spent prior to trial preparing for issues other than the fiduciary, given that 13 causes of action were alleged?
There is a lot of the case was involved with things that we have not discussed at all. Initially, the plaintiffs sought not $375,000. They sought $750,000. They sought Ms. Wallace's partner's share of the contingency fee as well. And I agree with Mr. Abney that the plaintiffs' appellants had some very creative claims that we paid very little attention to.
Well,
the breach of contract claims.
Mr. Garcia was originally part of this lawsuit.
He was originally part of the lawsuit.
That's what I'm saying. So he was part and parcel. I mean, he not only did he testify, but he was actually sued.
He was sued, but he didn't participate for a very long period of time. But it just gives you an idea of that there's a lot more that was happening than, breach of fiduciary duty was not it was not a big part of the claim ever. And so the concept that it was the focus of the lawsuit is a fabrication. I don't think Mr. Abney he's not part of the fabrication. He's saying that it should have been what the claim was about, but it was not the way that the case was tried. The case.
Do you agree with Mr. Abney that the word fiduciary never even came up until the fourth day of trial?
Not to the jury, it didn't. There was discussion between counsel and the judge concerning the cause of action, and there was discussion with the jury about the jury instruction, and that is it. And if I might, Your Honor, the important. I think that it's important, and I do think that jury instruction is important, but it's hard at this point to decide how to address this, because one of the things that Your Honors talked about was the idea of an implied contract, and this case was not tried as an implied contract, under an implied contract theory. It was tried under an express oral contract theory. And the reason for that is that there was an agreement that was alleged by both parties, but the terms of the agreement were different. The terms of the agreement by Ms. Wallace, which the jury accepted, was that she was going to work on the cases, these employment cases that the GSD law firm wanted her to work on because somebody had just recently left the firm. And she was also she had a few cases at Wallace and Garcia that she was going to work on, and they asked her nothing about what those cases were. And she made no statements about that she was going to wind down those cases. They asked her nothing about whether she was going to wind down those cases. And she made no representation that she wasn't going to continue working on cases in California, because they had no interest in that. So the agreement that they reached.
I thought she testified that there was an agreement that any new business would come into the Arizona firm.
That's not true. That's the theory that was asserted by the plaintiffs. There was testimony by the plaintiffs with respect.
There were potential clients that she met that were not signed by the firm, correct?
But those were people in Arizona. There was one situation where she signed up Arizona clients called the Reed Heads, and she signed them under Wallace and Garcia, her California firm, because she was concerned that the statute of limitations was going to run. And Mr. Phillips, the office manager, did not want to take the case because it was a wrongful death case, and there would be a major outlay of money. And he became concerned about that particular case, rightly so, that she had signed it up, and she explained that they kept coming back to her wanting her to take the case, and she didn't want the statute of limitations to run, and so she signed them up, and she wanted.
The point being is she attempted to sign the read heads with the Arizona firm, and only when instructed not to did she then turn around and sign with the California firm. Just so that the statute of limitations wouldn't run. That case was eventually run through GSD anyway. So that is nothing that was not actually an issue in this case. So, but if we're talking about what was the terms of the contract, about whether she was going to have just the California cases that she had prior to, because you said she could continue to work on California cases. She testified that she represented that she was never asked to say anything about any California cases. But really the only important case was the Burke case. She testified that she had a few cases in conversations that she had with the members of the firm in 2 different interviews that she was working on at the time, and she intended to continue working on those cases, and they agreed that she could work on those cases. And the Burke case was one of those cases, which turned out to be 5 cases. And the jury accepted that because it ruled in her favor. And whether this was a breach of contract case or whether it was a breach of fiduciary duty case, given the jury instruction that existed, there was 2 ways that the plaintiffs in the case could win, and only one way that my client could win. The only way that my client could win is if there was an express agreement that my client could work on the Burke case. Because if you look at the jury instruction, and the relevant portion of the jury instruction is excerpted in my brief, and I'll just read it. It's at page 18, and it's in the record at 237, page 5. Plaintiff has alleged that defendant breached her fiduciary duty owed to plaintiff. An employee owes her employer a fiduciary duty, which includes a duty of loyalty. An employee may not compete with her employer absent an agreement to the contrary. So, in order for the jury to find that my client didn't breach the fiduciary duty that Mr. Abney's been talking about, and that my client didn't breach the contract that was the thrust of the claim by the plaintiffs in this case, the jury had to find that there was an agreement that my client could work on the Burke case. And so the fallacy that the thrust of this case was a breach of fiduciary duty case, and the attempt to hide the fact that it was brought and litigated very hard as a breach of contract and a breach of the covenant of good faith and fair dealing claim, that was lost.
and which gave rise to an attorney's fees award, which the amount of which they didn't even dispute. It should not give rise to a reversal because there's no basis to reverse the award. The theory, if you looked at the closing argument of Mr. Durant, you would see that he mentions breach of fiduciary duty for about less than a page of his argument. He talks about breach of contract in the first 4 or 5 pages, half a page for breach of fiduciary duty, and then goes on with breach of the covenant of good faith and fair dealing. The whole thrust of their argument was to establish that Ms. Wallace had gone beyond the agreement that they had reached, and attempting to show that what they had agreed to was that she was going to do a few cases, and that this Burke case
And
was
she wasn't
not
going to sign any more cases in California.
Yeah, and that this Burke case was not among those few cases. And the jury did not accept that argument. And all of the citations to what are identified as uncontradicted facts in appellants' briefs are facts which are contradicted by facts which Ms. Wallace stated, and therefore are the facts that were accepted by the jury's verdict, and therefore are not the facts that the appellants needed to use in order to attempt to reverse the decision of the jury. If the court has any questions, I'm happy to answer. Thank you.
Counsel, thank you for your argument. Thank you. We're going to take this under advisement at this time, and we will be issuing a ruling in due course. Again, thank you for your time here today.